morning. Thank you, everybody, for coming. My name is Attorney Patricia Bloom McDonald, and I am an elder law attorney, estate planning attorney. I do work with probate and real estate as well. And I'm here today to help you learn a little bit about the basics of what estate planning is all about. So can I see a show of hands to see how many people know what estate planning is?
Basically, yes.
Okay. So if you own a house, if you own a car, if you have bank accounts, that's part of your estate. Okay? And you want to protect those. So that's what I do. I help people protect their assets, whether it's for retirement or for long-term care in a nursing home, or for vacations, for passing on to grandchildren. That's what I help people do. So today I'm going to start by talking about the basic documents of estate planning, and you probably already know all this. Is a document that you name somebody to be your spokesperson if you cannot manage your own medical needs. The pens that I put in these booklets have a little red nip on the end of them. You have to take it off. It's to help the ink from drying up. So a healthcare proxy is a document that names somebody to take care of your health if you can't do it yourself. And that's important because you want to make sure you do it while you have your mental capacity, and that nobody questions the person that you've named. You want to make sure that somebody has talked to you about what you want for your medical needs, and so is making these decisions for you in your best interest. Sometimes you are permanently mentally disabled, so you can't make those decisions, and the healthcare proxy person that you named will make your decisions for you. But sometimes you're just going in for surgery, and it's temporary. So a healthcare proxy only operates when you cannot articulate your own medical needs. So if you're just going in for surgery and you're under anesthesia and something happens in the surgery, the doctor comes out and asks, how do you think we should manage this particular medical need? That healthcare proxy person will make a decision. But you come out of surgery and you're mentally clear and lucid, that healthcare proxy can no longer make any decisions. So it only operates while you cannot articulate yourself. Sometimes, though, a person may say, well, I don't want to make any decisions anymore. I'm just tired of it all. I'm going to let Susie make my decisions for me, because Susie was the person she named in the documents. And that's okay. Okay? It's only if you cannot or do not want to articulate your own needs. And the healthcare proxy only operates during your lifetime. So as soon as you pass away, that person can no longer make any decisions. Of course, it's understandable. You're not alive and your health decisions are unnecessary. But that's what I call healthcare proxy is a living document. Your other living document is a durable power of attorney. A power of attorney is naming somebody to make financial decisions for you if you cannot or do not want to make them, or if you cannot get to the financial institution. But a healthcare proxy that you name can also do it immediately, even if you haven't given them permission. So you always want to make sure that you name somebody that you trust. Now, a durable power of attorney means that it operates during your incapacity. And it does not have to be redone should you lose your mental capacity. And that's why I only create durable power of attorneys. I don't create any other kind, because if you have what's called a springing durable power of attorney that springs into action when you lose your incapacity, you need 2 medical doctors to verify that you no longer have the mental capacity to make those financial decisions. You don't want that, because in a medical emergency, you need something done immediately and you can't wait for 2 doctors to make that decision. So I always do durable power of attorneys. And the durable power of attorneys I create are full of many, many powers, giving the durable power of attorney the right to access your financial documents, to make deposits or withdrawals, to make a mortgage, to make a reverse mortgage, to assist in paying a nursing home if you're in a nursing home, and many other powers. So you want to make it as broad as possible to not limit the durable power of attorney, but I also insist upon having the durable power of attorney sign the document so they know that they are responsible for making decisions that are in the best interest of you and not for them. So it's very important that you name somebody that you trust. You don't have to give them the document right away. You can hold it and tell them where they can find it, or you can leave it in the attorney's office and let them know the name of the attorney so they can get it when and if necessary. Problem with some of the durable power attorneys in Massachusetts and banks is that some banks say that after 5 years these documents go stale. So you want to show this durable power of attorney while you have your mental capacity to the bank that you do most of your banking and ask them, if something happened to me, are you going to honor this document? Now, managers in the bank are different. So there are many different branches, and every branch has its own manager, and some managers interpret it differently than others. I had an experience where a client's grandmother had the will in the safe deposit box and named her daughter and granddaughter as the durable power of attorney. The daughter had passed away and she had not updated her document. So the granddaughter was supposed to be the one to make the decisions. The bank would not allow the granddaughter to get into the safe deposit box because it was 20 years after grandma had made the document. We had to go to court and get a court order to get into the safe deposit box just to get the will out. So number one, I don't want you to keep your will in the safe deposit box, or if you're going to, make sure that that person has signature rights to get into the safe deposit box. And 2, check with the bank to make sure that they're going to honor this durable power of attorney, and review your document at least every 2 to 3 years to make sure that the people that are still alive that you named, that you haven't changed your mind. Sometimes we fight with the person that we named and we want to change that. You want to update your documents or make sure that they're current at all times. Yes?
You mentioned that for the power of attorney, that in the case you mentioned, that the bank wouldn't honor it because it was too long?
Too old. Too old. It was, they called it stale.
Okay. Is there some, you mentioned like every 2 or 3 years review your power of attorney, right? So then that would take care of that, as long as you have to redo it every few years?
As long as it's current every 2 to 3 years, you don't need to redo it. But if it gets past 5 years, you want to make sure the bank is going to honor the document. Now, some banks or financial institutions like Fidelity won't recognize a durable power of attorney that an attorney like myself has created, because they have their own documents. Now, there is nothing in the statutes that say that they cannot honor that document. Statutorily, those documents that an attorney at law created are perfectly valid. But financial institutions say, no, we have to answer to a higher authority, our depositors, so we are going to make people sign our own documents. So I know Bank of America and Fidelity have their own documents, so if you have your finances in those documents, you want to check with them and use their form to fill out and make sure that they have a copy of it on file so there aren't any issues later on. Yes.
What's the difference between the power of attorney and the durable power of attorney?
A power of attorney is just a regular power of attorney that stops being useful once somebody becomes incapacitated, mentally incapacitated. A durable power of attorney operates operates presently and then during that person's incapacity. So that's what the durable means. It can be used while you're clear-minded, and it can be used when you have lost your mental capacity. Yes?
If you have your children as beneficiaries for all your accounts, do they still need to use that to access my account?
A beneficiary only has access to your account at your death. That's what a beneficiary is. It's different than a signature right. If you're giving them a signature right, then they can access it without a durable power of attorney. If they're only listed as a beneficiary, they will need at least a durable power of attorney to access that bank account. A durable power of attorney cannot be used at your death. It ceases to be useful. That's when the executor takes over. So you name an executor. In Massachusetts, we call them a personal representative. The laws in Massachusetts changed in 2012 to the Uniform Probate Code, and now the term is called personal representative, but it's the same thing as an executor.
I have a
Yeah.
question. I was told that if you do put another child's name on your bank account and they got sued, that money is theirs. So I did the in trust like she was talking about. Does the signature right protect you from them getting sued? Is that just so that they can write a check, or does that give them full authority on my account?
It gives them a signature right gives them full authority, and at your death, that signature that means that that person owns the money in that account. So if there are multiple siblings, by law, they don't have to share the money in that account because they're a co-owner.
If that person got sued, they can't touch your account.
If that person got sued, they're a co-owner, so they can.
Oh, okay.
It can be attached. Yes, it can.
Okay.
Because they're going to use their social security number. They're going to be a co-owner. If it's just as a beneficiary, they will not be able to attach the money. If you'd like to pick up. So again, the healthcare proxy and the durable power of attorney cannot be used once you pass away. Okay, those are what I call living documents.
Do they have to show the documents at the bank?
Yes.
Or at the healthcare, they have to show the...
Yes. Now, for a healthcare proxy, you only want to name one person at a time. I've had recently a client come in and they'd named 3 healthcare proxies to operate together. You don't want to do that. Just one person at a time. You can name all 3, but be successors, okay? So if Susie's number 1 and she's not able to do it, then you can name Lucy as the second one. And if Lucy's not able to do it, then you name Nancy as the third one, okay? But Susie, Lucy, and Nancy do not operate together. That's because if there's some emergency in your health, you don't want everybody to have to be called and contacted to make a decision while you're bleeding to death on the table. You just want one person to make that final decision. And I apologize if I get graphic. I just want to get that point across.
So it's not decision by committee, it's decision in order.
Exactly. And the durable power of attorney is a little bit different. You may want to name 2 or more people because this is your finances. So you might have checks and balances. Have 2 people make that decision. So one person is not able to withdraw money without the other person's permission. Okay. You don't want to name Susie or Lucy. You want to say Susie and Lucy. That's important because if you only name Susie or Lucy, each one of them can access those accounts at different times without letting the other person know, and then everything gets messed up. Okay? So it's always important to, that little word "and" is very important. Okay, so let me see here. HIPAA release is another document that I recommend. I, in my documents, put HIPAA language in each of my documents. A HIPAA release stands for Health Insurance Portability Accountability Act. It is to protect your privacy. It's also to protect the doctor, so the doctor doesn't get dispense medical information about you without your permission. So these documents are created to name who you want to have information about your health. The people that you name in your HIPAA do not make decisions. They only can get information. That's all a HIPAA is. And it covers your ability to get that information about your loved one, but it also covers the doctor from allowing that information to be dispensed. And again, that document is typically used only during your lifetime. However, a HIPAA may be used to access medical records. But there's some controversy about that. So now I want to talk about estate planning documents. There's a will, and then there are trusts. There are many, 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 many different kinds of trusts. But first, I want to talk about the will. A will is a document that names your loved ones, or anybody actually. You can name charities, you can name your cousins, you can name, your friend, you can name anybody you want to get your assets. Your children are not obligated to get your assets. If you want to disinherit your children, you can in a will. If you don't have a will, your children will get your assets. If you don't have a will, somebody that you may not want to inherit your assets will get your assets. So it's important to have a will. I also recommend sometimes, depending on your age, a trust built into a will, and that's called a testamentary trust. It's a trust that gets enacted once you pass away. It's not a trust that is used immediately. So, for instance, if you're husband and wife, and one person is in a nursing home, and the healthy spouse, the community spouse, passes away, you don't want the nursing home spouse to get your money because they're going to lose their benefits if they're getting Medicaid. Because in Medicaid, you can only have $2,000 in your name per month if you're a Medicaid recipient. So what I do in my documents is I build in a testamentary trust. And what that does, it says that if I pass away and my spouse is in a nursing home on Medicaid or receiving any government benefits, I want the money that would normally go to them go to a trust. And that trust will pay for fluffy slippers or a new TV or, gourmet food that you're not going to get in the nursing home, but it will not pay for the same things that Medicaid. And then at the passing of the nursing home spouse, that monies will then go to the ultimate beneficiary that you name in your will. And then there are trusts. There are many kinds, as I said before. The reasons for having a trust is, one, privacy. A will always goes to probate, and becomes a public document once it's filed with the probate court. A trust does not go to probate, so it keeps everything private. Also, sometimes you have a disabled child, so you want to set up a trust for that child so they don't lose their Medicaid benefits. There are revocable trusts and there are irrevocable trusts. A revocable trust can get revoked, so that Medicaid will not disallow those benefits. In other words, the assets in a revocable trust are reachable by Medicaid. Because it's revocable, they'll say revoke it, spend down the monies in there, and then come and apply for Medicaid later. An irrevocable trust, after 5 years, cannot be revoked. An irrevocable trust can never be revoked, even before 5 years. But the Medicaid will not look at the assets in an irrevocable trust after 5 years. They will say you put your monies into an irrevocable trust to make yourself poor and qualify for Medicaid. That's a big no-no. So we're going to say you come back to us after 5 years after you've spent down the amount of money that you put into the irrevocable trust. They will never take your house. Medicaid will never take your house. They may deny you benefits. They may put a lien on your house, but they will never take your house. So people worry about losing their house to a nursing home. I do recommend life estate deeds to protect the home. A life estate deed is a deed that you name a beneficiary on. So you remain the life owner of the house. You pay all the maintenance on the house. You get to live in the house for the rest of your life. Nobody can sell it from underneath you. When you take your last breath, the beneficiary owns the house. And the beneficiary in this case is called the remainderman. So if you name your daughter as the remainderman, when you take your last breath, daughter owns that house outright and it does not go through probate. So Medicaid cannot force the daughter to pay your medical bills because through the assets of the house, because you own the house, or you had the Medicaid benefits, not the daughter. The daughter is not responsible for your Medicaid being paid back. Yes.
If you don't own a home but have assets, like bank accounts, IRAs and everything, is it good to still put it in an irrevocable trust? Just if you don't own a home or...
Okay, you want to, for irrevocable trust, you cannot be manager of your trust, okay? Somebody else has to be the manager of your assets. So you want to look at whether you want to lose control over your assets. If you're older and you don't care and you don't want to manage your assets anymore, an irrevocable trust is an excellent document. If you are younger and you still want to be able to control your assets the way you want, a revocable trust may be your option. You also want to consider, why are you doing a trust? Are you doing it for privacy? Are you doing it for to avoid probate? Are you doing it because you have special needs, children? So there are different reasons for doing trusts, and a trust is not necessarily appropriate for everybody. It's a good way to shelter tax benefits, tax debt. For instance, if you have an estate over $2 million, and you're married, you may want to do a credit shelter trust so that you can take advantage of the estate tax. There are also life insurance trusts. It's called an irrevocable life insurance trust, an ILIT. And those trusts usually are purchased in the amount of the estate tax that you think that your estate is going to be are vulnerable to, and that insurance policy will pay those estate taxes so your children don't have to. It gets more complicated as it goes on, so I'm not going to go into too much detail right now.
On the life estate deed that you were talking about, does that have a 5-year look back also?
Yes, it does. Yes, it does. And there's also a formula. A life estate deed, there are pros and cons. One, it takes, the con is there's a 5-year look back period, and you retain a value to your life interest. So if you need to go into a nursing home, they look at certain tables that they've created through POMS, which is I forget what the acronym means. It's POMS, and there are tables, and they will give Medicaid and your attorney at law ability to calculate the value of your life estate. So typically what they do is they look at the value of the home that you put, that it was when you created the life estate deed. They'll look at your age at the time you're applying for Medicaid, and they will look at your life expectancy, and they will calculate what that value still is. And sometimes it's worth maybe $2,000, and other times it's worth maybe $300,000, depending on the value of your home and your life expectancy, etc. So that's a con. The good thing is that the remainderman can never sell the house out from under you, and you can never sell the house without the remainderman's permission. So there's a checks and balance there. If you want to sell your house, you have the remainderman relinquish their future interest as a beneficiary, and then back to you, and then you own your house outright, and then you can sell your house however you want, and you have all those assets.
You said that, remember, they have to agree to
Yes.
it? So you just can't say you're no longer involved in this and...
No, they don't. So that's maybe a disadvantage to you, but that's why it works, because when you take your last breath, that remainder person owns the house outright, and Medicaid cannot put a lien on the house because the person who owns the house outright didn't die, okay, is not going to probate the real estate, and the house goes directly to the remainderman and is no longer owned by the person who is receiving Medicaid. Any other questions about life estate deeds? No. Okay. Okay. The other thing that I want to talk about are homesteads. If you're over at the age of 62, you may want to create a homestead. A homestead under age 62 gives you $250 worth of equity protection. That means if somebody sues you, equity is what the house is worth over the amount of a mortgage. Okay, so you may owe $200,000 in a mortgage, but your house is worth $500,000, so you have $300,000 of equity protection. A homestead will cover $250,000 of that equity protection if you're under 62. If you're over 62 or disabled, you can do what's called an elderly or disabled homestead, and that gives you $500,000 of protection. And if you're married, you can stack them. In other words, husband gets $500,000 and the wife gets $500,000, so you have $1 million of equity protection. Now, this protection is good for somebody. You're driving down the road and you don't see them and you kill somebody on a bike or something. Okay, that person can sue you and attach your home, and if you have enough money for the value of that suit, and you don't have a homestead, they can force you to sell the house to satisfy that suit. If you have a homestead, they can still sue you. They can still get a lien on your house, but they can't force you to sell that house. They have to wait until you're good and ready to sell, and then liens typically only last 20 years, So if you're in a house for 25 years, that lien is not valid any longer. So I highly recommend an elderly homestead.
How do you get a homestead?
You could go directly to the Registry of Deeds and they can fill it out, or you can go to an attorney's office and they can do it for you. And it's very reasonable. It's one-time fee. You don't have to renew it all the time. It's not like insurance. There's not an insurance policy that has a premium on it. It's just a one-time fee to create it and a one-time recording fee at the Registry of Deeds.
We had a meeting on homestead, and if you already had a homestead like I did before I was 62, you have to do a new one after 62.
If you want to,
realize it wasn't
you
valid.
don't have to. It's still valid. It's still valid.
They said it wasn't.
The $500,000 of protection is not valid. You only get the $250,000 of protection.
Oh,
Okay.
well, I redid it.
Yeah, I mean, if you want the maximum protection, you should redo it. You don't have to redo it. Okay. If you don't think you have any more equity than $250,000, there's no reason to redo it. But it's so economical to do it. It's silly not to. If you buy a house, you always want to make sure that the attorney creates a homestead for you so that you have that protection immediately when you buy the house. Now, another document I find very useful is what's called a final disposition. You're telling your family how you want your body to be managed at your death. Do you want to be cremated, or do you want to be buried? What funeral home do you want them to use? What cemetery do you want them to use? Where do you want your ashes to go? And who is to contact that funeral home at your passing? I've had couples who've been divorced, and ex-husband comes and tries to manage the funeral of his ex-wife who passed away, and there's a big fight in the family, and then they have to go to court. If they have one of these documents that's signed and witnessed and notarized and brought to the funeral home's going to honor that, and it eliminates a lot of arguments. Also, I don't know if you remember Ted Williams. He wanted to be frozen, and then he told another family member he wanted to be buried. This also lets people know how you want to be handled. Do you want to become a diamond? You can do that, or you can have your ashes brought to the ocean and sprinkled. You need to communicate with your family about these things. And this document will be in black and white, so there's no argument as to what's going to happen at the end.
What was the document again?
It's called a final disposition document. I don't know if all the attorneys do it, but that's something that I do, because I find that it eliminates a lot of arguments. Okay, so are there other questions? Did I talk about things that you're here and interested in hearing about?
Would this be very practical? How does the attorney get paid? You get paid all the time while you're dealing with it? How do they get paid?
Okay, well, in my firm, I can only talk about my firm. When you come into my office, I charge $375 for the first hour, and then if I get hired to create the documents, I deduct that $375 from the total of the cost of preparing all the documents, and then I take 1/2 of the value that I created up front. It doesn't have to be paid all at once, but once I receive 1/2 of the total cost of preparing the documents, then I prepare the documents. And then I mail the documents to the client in draft form to review, to make changes. Sometimes we make typos, I make mistakes like everybody else. And once the client approves them in final, then we will create the document in final. They come back to the office, they sign the document in final form, in front of 2 witnesses and a notary, and then they pay the balance at that time. And there's no additional fee after that.
What about re-examining every 3 years?
Right. If you come to the office, today it's $3.75 an hour. Many times I give current clients a discount if that's, if they call me with questions first year, I answer them for no cost. Emails are usually no cost after the final documents are signed. But if I give an hour of my time, I do charge for that hour. But again, if you hire me, then I deduct that. So essentially, it's for free. Anybody else have a question?
So at that initial visit, you're just gonna go over all the documents and how much it's gonna cost to do everything?
But I have a long conversation. Sometimes we go over an hour, and I only charge them for that 1 hour. I answer everybody's questions. I review their finances. I give them all my legal advice. And we talk about who you want as your executor, who you want as a backup executor, who do you want as your healthcare proxy, who do you want as your backup healthcare proxy. I have a form that's maybe 6 pages long. I don't pass it out in advance. I do it with the client, and I hold him, essentially hold their hand, because they're nervous. They don't necessarily know how to fill out the form. They get overwhelmed if they do it by themselves, so I work with them to fill it out. And it's not until I get a full picture of exactly what their estate consists of that I can give any advice or costs. I don't give estimates until I know everything, because all of my documents are created individually for the client. I don't have a database software that that you just plug in the names and then the software spits it all out. Everything is done
So
individually.
what did you say, half of something?
Half of the costs of preparing the documents
Oh.
is what I take initially, and I also have them sign an attorney-client retainer, because I can't legally represent somebody until I've been retained. Okay, so I have to have a document that says, yes, I retain Patricia Bloom McDonald, and yes, here is my retainer fee. So then I'm legally obligated to represent you, and then I prepare the documents. I do have a wonderful paralegal, and she is, you can talk to her, ask her questions at no cost, and she actually does the computer work. I don't do that part.
So the retainer fees in additional?
No, it's part of the total
part of
cost,
the-
yeah.
okay.
The only thing that's extra besides that is recording fees at the Registry of Deeds. I don't have any control over what the Commonwealth of Massachusetts charges for recording a deed or a homestead, so those costs are in addition. And if you have a trust, then there's a trustee certificate that needs to be recorded, and that cost goes to the state, not me.
So if you don't have a trust on your home and you pass, your kids get the home?
Not necessarily. It depends what kind of document. If you have a life estate deed, then the kids get the home. If you don't have a life estate deed, if you just have a regular fee simple deed, then and the real estate deed is in your name, then the deed stays in your estate, and then according to what kind of documents you have, it goes through probate. If you have a will, the will should always say that you waive the need for a license to sell, so that the family does not have to go back to court and get the license to sell. Massachusetts puts an automatic lien on real estate, so that you have to get that. The reason is because if there is a state tax, they want that paid to the state of Massachusetts and the federal government, and they want a release of the estate tax. If there is no estate tax, which means that if you have an estate over $2 million, if there's no estate tax, then there's no need to file or pay any taxes, and there's no need to go to probate to get a license to sell. But if you don't have that language in your will or your trust, then you're going to, it's going to be questioned whether you need to go and get a license to sell. And there are different times. If it's over a year old, you don't have to. Your estate, if you died a year before your house is being sold, then there's no need for a license to sell. But if your family wants to sell your house within the first year, then you have to go for a license to sell unless you have that language in your will. And if you don't have a will, then you always have to go for a license to sell before during the first year.
If you don't have a will, but the house, you have a beneficiary listed.
Where is the
Yes.
beneficiary on it? Is it a life estate deed?
I don't know. It's on the, I don't know.
Okay.
I know there's a beneficiary on my house.
Okay, so it's hard for me to answer that question without seeing it, because normally there isn't a beneficiary on a deed. You either own it individually or you own it with somebody else, or you own it in a life estate deed. There's also, you can own it until there's another way of doing it. You can say, Susie Jones owns this house for her life, and then daughter Sally Jones owns it at when she passes. That's called a life estate deed. Or you could say Susie Jones owns this house. That's it, okay? And when she dies, it goes into her estate. You can say Susie Jones and Harold Jones own this house, tenants by the entirety, which means husband and wife. So when Susie Jones dies, Harold owns the house. Or Harold dies, Susie owns the house. Or you could say Susie Jones and Joanne, Smith owns this house. But tenants in common, that means you each own 50%. So when Susie Jones dies, half the house goes into the estate, and Joanne Jones owns the other half, and she only owns half the house, but she's still alive, so she has to, if she wants to sell, she has to get permission from the people who are in charge of Susie Jones' estate to sell.
You can put that on the deed?
What
That you just said, the life estate is deed?
if you own a house with somebody else, if you own it joint tenants with rights of survivorship, or that's called JTROS, in case you see that language on your deed, that means you own it jointly, and that when you die, the other person owns it outright. If you own the house with tenants in common, that means you own the house together with somebody else, but when you die, that half that you own goes into your estate, and the other person owns the other half.
So if you put your kids on the deed of your house, you would have to get their permission to sell?
No, if you own, well, if you're alive, yes.
Yeah.
If you've passed away, your children will own it, as long as you retain the right to live in it. If you put it, Susie Jones, Sarah Jones, and Melissa Jones as joint tenants with rights of survivorship, then if one dies, the other two still own it. If two die, the last one owns it. Okay, maybe that's what you mean by a beneficiary.
Because I know the house is just in my name, so if I pass away,
Then
she's
it's-
the beneficiary.
Then it's probably
And
a
I know
life
it got
estate deed.
recorded.
Huh?
I know it got recorded.
Yeah, it's probably a life estate deed, but I'd have to look at it.
Okay.
if you don't own a home but have assets, like bank accounts, et cetera, and all your accounts have their kids as beneficiaries, is a will or a trust needed still?
No.
No.
And that's a very good question. If you put beneficiaries on all of your assets, you do not need to go to probate, okay? You don't need to open a probate.
If you don't own a home.
Even if you own a home, you want to make sure that you name somebody who's going to own your property after you die, okay? So whether it's tenants in common or joint tenants or tenants by the entirety or a life estate deed, you want to name somebody who's going to own it at your death, okay? So same with bank accounts. Same with, you know, a boat, anything that has a title to it. If you own a mobile home, you want to set up, you could still have a homestead, by the way, on a mobile home. And you can also set up I had a client rather who had antique dolls, and she wanted to make sure that her daughter got the dolls. So we set up a document that is similar to a life estate deed, actually. It says that at my death, I want my daughter to own all of these dolls, but until then, I own them and I take care of them. That way, nobody's going to fight over these dolls at her death. Okay, so there are very creative ways of making sure your assets are taken care of. I don't put itemized documents in your will because the will becomes a probate document and public document. Then everybody knows what you own. Okay, and my aunt, when she passed away, had all of her, you know, personal property listed in her will, and her house got robbed before it was she was in the backyard. Somebody walked in and just robbed her because they knew her will was in a public document and they knew what she owned, and she got robbed. Okay, so you don't want everybody to know your business. Also, probate gets assessed against your property, and you are supposed to file an inventory with the probate court to let the value of your estate be known. But that's private. It should be always private.
She was still alive, your aunt?
Yes, she was. No, you're right. She was not alive.
Oh, okay.
Her family, her cousin, her daughter was in the backyard.
Okay.
And but because her will was in
Yeah,
public document, they got robbed. So I give I give a document, what's called a memorandum, so that you can list your property and that and who you want to go to, but it doesn't go to probate court. That's private. So it's only for your family. It's easier. My mom put little labels in the back of everything of who's supposed to go to. You know, those labels fall off or they get switched, you know. So.
I saw in the flyer to come here today that something mentioning about other options other than a nursing home. It said in.
Well, there is home and community-based waiver. It's still a Medicaid program. I have to say a caveat right now. Medicaid is in Congress right now being discussed. And whatever I say today may be invalid tomorrow. I don't know what the future is, okay? And even if what I say today is valid for the next 3 years or next 4 years, another president can change it. So this is talking about what the laws are today.
And what did you call that? The other than a nursing home?
It's called a home and community-based waiver. It's similar to Medicaid, except that you can stay home. And a family member can be paid to take care of you.
Except for the spouse.
Right. It cannot be a spouse. It can be a daughter, son.
Which is unfair.
Yeah.
what's it called again?
Home and community-based waiver services.
Yeah, it's a Fair Elder program from Mass Health. I'm a
Yeah.
counselor.
Yep.
to be on Mass Health for that.
It's a mass health program, yes it is. There are other homes, old age homes that you can go into if you own too many assets. There's also low income housing that you can apply to. There's also a trust called a pool trust that you can put your money into to get your asset level down. There's also annuities that are Medicaid qualifying that you can purchase to get your assets down. There are many different strategies to qualify for Medicaid.
And if a person is on Mass Health, can they come after your money?
They don't come after your money. What they do is once you die and you open a probate, they will make a claim against your probate estate. Okay. Mass Health says that they can get dollar for dollar for what they've paid out on you. So they are named as the first beneficiary on an annuity or a pool trust, so they can get reimbursed. If you don't file probate, they cannot file a lien on your probate assets because you didn't open a probate. If you have a life estate deed, they cannot file a lien because your estate doesn't own that house. Your beneficiary or your remainderment owns the house.
But you're only talking about a home, not assets, like other assets, not.
That's correct. They don't go after your bank accounts and things like that. They don't know about your bank accounts. They have to do it through the probate court or the courts. Any other questions? Is there something else you want me to talk about?
Where on Route 6 are you? I know it's Westport.
I'm right on Route 6. Do you know where the Emerald Bus Barn is? You know where the old yarn shop used to be? There's a pet store. There's a driving school. I'm in that little strip mall right there.
Oh, the strip, okay,
Yep.
gotcha.
Question about, veteran benefits, that's,
Right.
someone, like, what's the difference between like a regular veteran and like a Gold Star widow or something?
Okay, those are the kinds of questions you have to ask a veteran representative. I do know that.
Just feel free to stop in my office and talk to me. I'm the veterans officer.
You're right here? Well, just don't be surprised if I'm there in front of your door.
Yep. I have a question for you. If a husband and wife, one spouse has been in the military, and but they both want to be buried together, how do they get the form or is there a form, or must there be a form to fill out so that make sure that the spouse and both spouses get buried together?
If it's at a national cemetery, such as Bourne, your funeral director will take care of that for you. A husband and wife can be buried together free of charge as long as the veteran qualifies, based upon his military service. And they will be in the same plot though. You don't get two separate plots. And all they need is a copy of the veteran's DD 214, which should be kept on file.
I always ask my clients to get a DD 214. Give me a copy of their DD 214. Yes.
And if they have problems finding one or getting one, just have them reach out to any veteran service officer, because we all have access to the mass database.
Yeah.
And it's pretty much accessible.
But it's best. It's best to get your DD 214 if you don't have it, to get it while you're alive. So
Absolutely.
it's so much easier for you to get it than your family member to get it, because you know what your military history is and your RA number or your military number, and it's much harder for your family member to get it.
And there was also a big fire in 1971 at the National Archives, and Air Force and Army records were burnt in the fire. So they're in the process of trying to scan, like, from Army and Air Force personnel, going back into their records and getting updated, but they're so far behind.
Yeah.
If you have a copy, now is the time to start looking for it.
Yeah.
If you can't find it.
That's,
Yeah, that's all it is. The funeral director will actually make the arrangements for you.
okay,
But I think you had spoken earlier about setting up what your wishes are.
yeah,
Once you pass, that's one important document that should be kept with that.
right. And whenever I send out my confirmation letters for appointments, I give a list of documents I want them to bring to the appointment, and the DD 214 is always on that list. And that's a discharge paper. Any other questions? Well, thank you very much for coming. I appreciate it.
Well, thank you for having us here.
Yeah, thanks for the information.
Thank you very much.
You're welcome. Those books are for you to take home, so if you want another brochure or
I'll give
another
this one
folder.
to our director.